preview video here that's very zoomed in. So good evening again, and welcome to another edition of the Justice and Pieces guest speaker series. Today's guest is Sujith Sutharsan, who is a criminal defense lawyer. So Sujith, again, for those who may have missed it, perhaps give us a little bit about your background, how you got into law and into criminal defense.
Yeah, so I'll give a shorter version, but basically when I was in high school is when I got an interest in law. That was when I first had a good law teacher that sparked my interest in law. I was taking the science route, but that's when law really hit me, and I went into University of Waterloo, took legal studies and business there, continued on to go to University of Windsor for law school. During law schools where I had more of an interest in criminal defense, especially, I focused on it. I took all the courses that I could on criminal defense. And leaving law school, I found an articling principal that mentored me, and he was primarily doing criminal defense as well. And since articling, I've like I was telling you earlier in the pre-discussion, I've only done criminal defense matters. I've done some POA and traffic, but apart from that, I haven't touched anything else. I haven't done any real estate or family or anything like that. So I want it to be my bread and butter. It makes me happy. So I'm going to continue taking on criminal defense files as long as I have the firm open, which is hopefully for a long time.
I think you wanted to shout out your high school and your high school teacher. Who's that?
Yes. Shout out to Mr. Jamie Glass. He actually won an award last year for being an innovator in law and helping law students or future law students while in high school, because in my class there was almost 10 of us that came out of that class and became lawyers. So shout out to Mr. Glass from Middlefield Collegiate.
Right, so I'm sure we'll circle back to that, because I think we have a few things in common. We were both from Scarborough. We both went to the University of Waterloo, and we're both in criminal defense. So a lot to take in here for us today. So maybe talk to us about getting into criminal defense, and maybe you can give us a quick criminal 101 of what it's like to be a criminal defense lawyer and the kinds of things that find its way on your desk.
Yeah, I guess originally, I think one of the reasons I really was interested in criminal defense and found it fascinating is I remember when I was in high school, I had some friends that found themselves in trouble, right? So they were, I guess, doing things that young boys do and got themselves in trouble here and there. And I remember they had to go find a lawyer, and ultimately these lawyers got them out of bad situations, and they ended up now they're 30-year-olds and they have a good life together, right? And I think that concept of being able to help someone's life in that manner and help them from probably the worst decision they've made in their life so far, I think that's what drew me to it from the beginning. For me, when I was debating between science and law, there's more something tangible more for me. I was okay, you know what? I'm directly can see the impact in this person's life right away. It was, and that was my draw to criminal defense particularly. And I went through law school, and I didn't really take opportunities like Zoom meetings like this, or interning with a lawyer, or volunteering at law firms to get a grasp of what criminal defense was. But I did something in law school where they offer you to work in some clinics, and I worked at a clinic, and that was where I got some experience there that furthered my interest. And when I was looking for articling, I knew I didn't apply to any of the Bay Street firms. I knew I wanted to pursue crim. So what I started doing is I started cold calling some people and seeing if they'd take me or have coffee with me. And then one lawyer, he was also, so I'm Tamil and he was also Tamil. And he was like, you know what, why don't you just join me for a coffee one day and we'll see what happens. And I remember meeting him for coffee, and he didn't ask me about my marks. He didn't look at my resume. He was just talking about life, and he seeing if we'd be a good fit, and if I can basically, if I'm getting into criminal defense for the right reasons, I guess. So we had a discussion about clients and what kind of clients to expect. Criminal defense, as I guess we know, there are a number of different clients that we see, right? I guess different areas of law, you see different types of clients. Obviously, property crime, you're dealing with a lot of impoverished people that are making these mistakes not because they for fun. It's because they need to, right? There's sometimes small thefts and small types of frauds that are happening because these people are having trouble making ends meet, and they want to put food on the table. And so there's that type of clientele. Other type of clientele that simply feel that it's a lucrative opportunity. I know there's clients that get into, for example, drug trade because there's a lot of money there that could be made, so they take the risk. So there's all kinds of clients that you run into, even at a higher corporate level. Some people that white collar crime, we've seen it on TV. It happens. So there's in criminal defense, it's all different types of clients. I particularly, I think, being from Markham Scarborough in that area, I've dealt with a lot of minority clients. I think that's sort of been what I've been doing for the last 3 years. I would say about 95% of my clients have been either brown or black. So I think that especially makes it more relatable for me. I'm like, whenever I see them, it's like, okay, I see like a friend or it seems like a family member. So it's easier for me to step up and go to bat for them. And I personally, especially with the younger clients, going back to where my initial goal was, hey, I want to help these people through it, right? And I remember when I was when I was a lawyer and I was starting my practice, I had a lot of concerns about like whether I was doing the right thing. And then I helped a couple of young clients, and a year later they had messaged me and said their thanks about a year later. And I was like, wow, this person still remembered me a year later and reached out to me to say thank you for that moment in their life, for stepping in and helping them. And that's when it sort of sold it for me, where I'm like, you know what, like I love my job. I want to keep doing this for as long as I can.
Now, did you have a plan coming out of law school? Did you go into law school like I definitely only want to do criminal defense, and did you sort of take courses geared towards that, or was it something that kind of evolved naturally? And then when you were looking beyond, after your articles, and I want to focus in on this area, what sort of came about?
Well, I don't know if everyone would share the same mindset I had, but for me, especially coming from a minority family, and I didn't know any lawyers, right? So I didn't know anyone that had gone to law school. It was a totally new experience. I had no one to really talk to about it. I never thought I could even reach out to lawyers and talk to them about their experience. And I think that's why I'm always willing to volunteer for events like this, because it's important to sort of get that knowledge out there about like the fact that, hey, like this is doable, like this is one person's experience and you can possibly go through it too. So I remember going to law school and I was sort of at one point just grateful to have gotten there, right? Like I didn't even think about the grand picture of things. I'm like, hey, like, I'm in law school and now what's the next obstacle? The next obstacle is trying to pass these courses, right? So I wasn't really thinking big picture. In law school for us, first year is pretty much designed for you have to take the courses you have to take. You're taking a little bit of everything, criminal law, constitutional law, property, all of it. So we had to take a little bit of that. So I didn't really start thinking about it until second year. And then you run into this predicament where like, hey, do you take classes where, you might do well, or you might know friends that are taking those classes, or are you going to try to take classes that you're interested in? And that whole process gets a little confusing. And then you're also like, okay, imagine I'm trying to take a criminal course, but it's also competing with a torts class that I have to take. So it's in the same time slot. So what do I do, right? How do I move my schedule around? So there's obstacles like that I went through in the first 2 years where I was so worried about just surviving law school that I didn't think about the grand picture of things. When realistically, like I was saying earlier, like I should have been volunteering at firms. I should have done I did my clinic experience in the third year. I should have done clinic in first year, second year, and that was like a hands-on experience. And so I didn't do all of that. So only in third years where I was like, okay, you know what? Let me think about what areas of law really interest me. And that's when criminal defense really stood out. That was, I took almost every criminal defense course possible. I found it fascinating. And coming out of law school, I had a little bit of experience in a personal injury firm. And when I was applying to article, the only interviews I was getting was from personal injury firms. And for me, it was like, do I go into personal injury perhaps and get paid whatever they're paying me? Or do I try to find a criminal defense position? And articling criminal defense positions aren't the best paying positions. I initially signed up to do unpaid, which was a huge decision, and I know I'm privileged that my parents were able to help me through that year, because I know a lot of people coming out of law school with law school debt can't do unpaid, and it's not something that they can decide on. Hey, do I go for this paid position or this unpaid position because I like this area of law? So I know I'm privileged in that sense that my parents were helping me through that year, but so I'm grateful that they helped me pursue my passion, because I was like, you know what, I don't care if it's unpaid. I want the experience. The mentor I sought out, he looked like me. He was Tamil. He had similar lived experiences. I wanted to work on the files because, like I said, like the people that we're working for were all minorities, and that drove me to work harder. And I think that transition from, hey, let me survive law school, let me go one step at a time, and then eventually getting to a point where I'm like, hey, I can do this. Like that took a long period of time, and longer than I think perhaps some of my colleagues did. Because for me, it was like a lot of a journey about, hey, like imposter syndrome, like, am I supposed to be here, and trying to fight through all of that in my head, right? So now eventually I got past all of that, and I'm at a point where I'm like, okay, you know what, I love my job, you know? So I think to get there, it took a lot of steps and a lot of, you know, I don't think anyone, especially at a student stage when you're thinking, can I do this? And you have those questions, like it's going to happen. Like, don't fight it. Like, don't be discouraged at the fact that you have these questions in your head. Like, think about it, you know, talk to other people who've been through it. And I think that's the best way to get through. And eventually, if you really like what you're doing, you'll get there. Right.
Now, Sujith, you brought up a couple things there.
Mhm.
Certainly, when I went to law school, I mean, we had some things, but nowhere near as much as the ability to connect on platforms like LinkedIn and other social media. What advice, maybe for students who are now where you were maybe 4 or 5 years ago, and they're looking to network, and they're looking, well, where are the Tamil criminal defense lawyers, and where are the young lawyers, or where are there people from this particular, let's say, IP law, or whatever it may be? What advice would you have for them listening, whether they're in law school or paralegal students here, about connecting with mentors and how to approach them, whether on LinkedIn or another platform?
I think that's a really good question. That was one thing that I struggled with, because for me, when I was going to law school, or first year, second year, I was thinking, hey, like I'm a law school student, like am I going to look dumb reaching out to a older lawyer and wasting their time asking them questions, right? But I realized that in general, the lawyer community is quite kind about these things. They know where students are coming from because they've been there as well. So there's this whole concept of paying it forward and helping people get access to becoming a lawyer and access to justice. And that sort of mantra has been going around for a period of time. I know, especially in Windsor, it was an important part of the education. So don't be shy. I think whether it's on LinkedIn or whether you see nowadays, like lawyers are transitioning to Instagram websites. There's probably some lawyers on TikTok, and the fact that they're so accessible to you, I think, you know what, there's no harm in reaching out and taking time to pick their brain. Of course, we're in a pandemic now. It's harder to have coffee or go meet in person, but I know there's a lot of lawyers that are willing to take phone calls. There are some senior lawyers, because as you may know, jury trials are not happening for the next period of time. Jury trials are being postponed. So I know there's some senior lawyers. I know it was Sean Robichaud, I believe, that had put it out on Twitter, where he's willing to talk to young students and young lawyers and just give them advice if they need anything, or they're looking anywhere for advice. He's willing to reach out because they have some more time that's in their schedule now, because these things have been postponed because of the pandemic. So I think just not being shy and reaching out. Your other question was for, like, if someone wants something specific. I think that's when you can Google things, of course. I think within the Law Society itself, there's different sub organizations. For example, there's a Black Students Association. There's SALSA, which is the South Asian Law Students Association. So going through those avenues, you can probably find other contacts, or at least people that you can relate to. And with respect to specific disciplines, once again, like you can do your research on Google, and or call the Law Society itself, and perhaps they can help you there as well.
Now let's talk a little bit more about your practice area here in criminal defense. First of all, you brought up Zoom. What is it like now in criminal defense, preparing for trials and everything in the midst of the pandemic? I mean, I noticed, your name is probably named there for the council there because you want to get spoken to there ahead of everyone else. But maybe you could tell us a bit about the Zoom experience in criminal defense right now.
I think when you're talking about the transition to pandemic lawyering for criminal defense, there's two sides of it. One is um, being your own businessman on the practice side of it, and the other part's the actual lawyering side. With respect to the lawyering side, the first thing that we as younger lawyers and paralegals, everyone that has to go through is set date court. Set date court is where you're going to court. You're usually representing these individuals in their early stages of their proceedings, where you're either they're trying to get disclosure done, or trying to book a pre-trial with the Crown, or you're trying to book a pre-trial with the judge. Where it's the earlier court dates for anyone that doesn't have any experience in criminal defense. That's a rundown or simplification of what set date court is. Now, typically, what paralegals and young lawyers will be doing is, if I had set date court and I'm working for a senior lawyer, and that lawyer has some matters in Brampton, they have some matters in Oshawa, they would either have to send different paralegals or students or young lawyers to those locations, or you would have to drive to those locations because that's where the matters are. I remember in articling, there was one time I drove from Milton to Brampton to Oshawa all in one day to try to get all these set date court things completed, because all of a sudden they were, for some reason, all on the same day. Now, the beauty of virtual court is now you're sitting on a computer. So you can log into these courts remotely, and you can there's a sign up list. It's a lot more organized, and you're signing up, and it's like right now I have like 3 computers here. So what I can do in the mornings is I'll be like, okay, if I have multiple court appearances, I'll sign in multiple computers. If I need to, I can even sign on my phone on Zoom, and I'll be monitoring both courthouses and have myself on mute to see when they're going to speak to my matter, and I can sort of jump in, right? So I think from so that part of court has been a lot less stressful. I know there's some big time firms where they'll have their paralegals or articling students like sit there with their list of like 25 things and just get just rip through everything all morning, right? So I think from a mental health perspective, from a logistics perspective, from expenses perspective, the fact that you're not paying gas fees to run around and do all these things, I think that part's gotten a lot better, and we should have went to that system a long time ago. With respect to preparing for trial, I think, as I'd alluded to earlier, the jury trials have been postponed for a period of time. Of course, it doesn't make sense to have a jury with that number of people in a courtroom. It just, you're asking for possibility of the virus spreading. So that part makes sense. But the unfortunate thing is, a lot of people are waiting for trial, are in custody, and we need to try to see how quickly we can move these files, because the more and more these trials get postponed, there's so much backlog that the whole system is going to fall apart. Now, for anyone that doesn't know, of course, there's a in section 11 of the Charter of Rights, they talk about a right to a reasonable trial without delay, and the courts are trying their best to make sure that these trials are had without delay. So what's happening now is judges are trying to force Zoom trials when capable, even though technically it should be up to the client to decide whether they want a Zoom trial or not. I actually had a friend today morning. She was a little irate because they had a jury trial with a pre-trial motion, and the judge agreed that the jury trial has to be postponed, but they're forcing the motion to go ahead over Zoom, which is going to incur some more expenses for the client and this and that, and it didn't make sense for the lawyer. But the judges are like, hey, like, we got to start forcing things and getting things moving, right? I personally have only done one Zoom trial. All of my trials during the pandemic have been with an interpreter. Now, interpreter trials are getting done in person. The thing about having an interpreter trial over Zoom is, let's say the judge is speaking, or the Crown is speaking, or I'm speaking, we would have to wait for the interpreter to interpret in a consecutive manner. Now, the weird thing about that is, let's say you have a trial scheduled for 2 days with an interpreter, that 2-day trial is likely going to become a 4-day trial because you're doubling up everything that's being said. So while in court, the interpreters are skilled enough to simultaneously interpret. So while I'm speaking, if I speak slow enough, the interpreter will be interpreting at the same time, interpret the client, so things move along a lot faster. So the courts have at least granted me access to have trials in person, because it allows those interpreters to get the job done, and we're not spending 4 days of court time and judge time on something that should be done in 2 days. So those are some of the considerations that are happening with Zoom trials with respect to juries and whether the client wants to do it or not. The only Zoom trial I did was technically a prelim. It wasn't even a trial, and it was one witness, and that client spoke English, so he understood. One of the other concerns I should also bring up is a lot of clients, it's not right to assume that all clients have access to the internet. I think people don't realize that some clients really don't have a computer. Some clients don't have a phone that can connect to the internet. And frankly, some clients are seniors and they're not going to be able to adopt to that technology. And to set a trial, assuming that this person can figure out technology that day is difficult. And what happens is, well, what happened in my case is my client didn't have a computer, but at least I was able to get him into the office and have something set up where we're both wearing masks and in a social distance enough, and I could project what's happening so we can all hear. And I was able to facilitate that for him. But of course, I understand. I was in court once, and one lawyer said, "Hey, like I live with my parents. My parents are both very old. I am not taking this risk by having a client come into my office," which is a very fair request, right? So I think those are the type of considerations that are happening, and I know we've been in this pandemic for unfortunately about a year now, but the Zoom and all of that's been going since September, so it's taking some time. But I think lawyers are slowly trying to figure it out. But I hope, eventually, the courts will open so these clients, especially that are in custody, I think they especially need to have their trial as soon as possible, because it's not fair for them to be stuck in custody and have to wait for the courts to figure these things out, right?
Now, there's certainly a lot of moving parts there. One being Jordan, right? And I don't know if anything's really worked its way through in light of the pandemic. And maybe you can explain to my students who don't know what the case of Jordan is about. But what about situations like you mentioned where the client is in custody, but you may really want to cross-examine the complainant, and doing it over Zoom is not as effective, according to a lot of criminal defense lawyers that I've talked to, because you don't get to see them, you don't get to put the documents to their face, you don't get to get the reaction. I mean, it's only above the shoulders as well. But maybe your client's in custody and you have to weigh getting them out of custody or getting through the trial first versus less than optimal conditions. Now, first of all, do you have a preference of doing it in person versus over Zoom if those considerations are there? And what if you don't want to have it on Zoom and now it delays your matter further? Is that your responsibility, or is that delay that is the fault of just the system that we're in?
Yeah, I think there's two questions there. The first question, of course, for anyone that's watching or any student that doesn't know about Jordan, I think that's of course an important area of law that has been debated for the last few years. Now, this is of course unprecedented. I don't think Jordan was calculating that there'll be this pandemic that would simply change the whole court system on its head. There's basically within Jordan, there's something called exceptional circumstances. And initially there was an argument that most of these trials are getting postponed are going to fall under these exceptional circumstances because it's neither the defense's delay or the Crown's delay or the institution's delay, because this was simply unprecedented. Now, I know there was a case that came out of Brampton. I don't have the citation off the top of my head, but that case was recent, and it sort of talked about now that the courts are open and over Zoom, there's still grounds for delay if the Crown's not moving things along. If the Crown's not getting disclosure to you, if the Crown's not setting trials, that kind of stuff can still be delay or a lack of resources, because if the court is unable to handle the volume of cases, the proper solution would be to simply hire more staff or something. There's something that can be done to move these things along faster. Now, my personal preference, I do agree with you. I think in person for cross-examination is a lot better. I think I've been in court sometimes where a witness will be testifying well, all of their direct examination, and then cross starts, and they'll all of a sudden start folding, and you can sense it in their body language, and you can see the way they're reacting to things or pausing. As we all know, it's a lot easier to say things over a screen or in front of a screen, whether it's random comments on YouTube or negative comments like that, or over Zoom. It's just a lot easier to, I think, do things over Zoom. I also have a little bit of a concern about whether, if somebody's on Zoom and maybe they have something written next to them that they're able to refer to, or we just can't see what's in the room, or if someone's trying to coach them through things, I'm worried about whether there's some sort of tampering that could happen, and a witness is perhaps, like, if they know that this is their statement and they have to stick to it, right? If they've written down all the details and they're looking up and just reading it, it's different, right? So I'd prefer to have it in person. Now, of course, I think once again, like, I'm going to check my privilege. Like, I feel younger and I feel healthy. Like, I don't have the same concerns as an older lawyer might have with the pandemic. But that being said, I personally feel for cross-examination especially, I prefer to go over in person.
Thanks for sharing. And I think certainly there's people on various points on that with respect to balancing the need to get through the trials, but at the same time, why run a trial or be forced into running a trial over Zoom that's has all those concerns? And certainly the coaching being an aspect of it, as much as the witnesses are sworn in and have to testify under oath. Nowhere there's a in that is that they're told not refer to anything, or again, they may not realize there's an issue with that. So certainly people are concerned about the coaching, or even just the additional access to their statement, or whatever pictures or documents that you wouldn't otherwise have in the court. So is there anything, I think, optimally here going forward from what we've done in the pandemic, whether it's the set date courts that should kind of stick around, or do you think that the sooner we can get back to normal with respect to trials and leading up to trials, as we had before the pandemic, the better for us?
Like, and this, I don't know, this may not be a popular opinion. But I do think most of my young lawyer colleagues will agree that set date court needs to stay virtual. I think that's it's saving a lot of people time. It's saving a lot of resources. You're saving the planet because people aren't driving around as much. I think it's very efficient to have it online. The unfortunate thing is, I do note that some set date courts, I think in Oshawa and Newmarket in the last few weeks, they were running till about 7 p.m., 8 p.m. when they're supposed to be finishing at 4. And I guess there's a lot of backlog and inefficiency happening at the courthouse. I'm not sure why it's taking that long, but I'm just assuming it's the backlog. Now, going back to what you said about Jordan and whatnot, I think what seems to be an easy solution, and maybe this is me being biased as a defense lawyer, is there are a lot of cases that don't need to go to trial. Like, if the Crowns are willing to offer a reasonable resolution, like, things will go away faster, right? But the fact that Crowns are still, like, I had a trial set in October where this guy had 35 charges, and ultimately there was a number of breaches on the arrest, and all 35 charges were withdrawn before trial. But during his time on bail, he ended up running a stop sign, and when the police came up to him, he was so nervous because he wasn't supposed to be driving that he lied about his name or something of that nature. That's the allegation. And I told the Crown, like, hey, like, he wasn't, only reason this all happened was because he was on bail and all the charges were withdrawn. Like, let's get rid of, why are we arguing this? Why can we withdraw this? Can he do a donation? Can he do volunteer service? Can he do something to have this go away? Like, he doesn't want to plead guilty to this. And the Crown was like, no, like, he still did it. So we're going to continue now. Like, I'm going to push this to trial, and it's going to take a day. And it's like, it seems like it's a waste of resources when it's something that, it didn't hurt anyone. It was something that happened because he was nervous while he was on bail. And I personally think if whatever happened, it should have been withdrawn. And we are saving a day of the court time, right? So the fact that these small things are going to trial, I think both sides, the Crown and defense, have to realize that, let's focus on what's important here. Like, let's focus on keeping people that are supposed to be dangerous out of the public. Let's focus on keeping, if things can resolve, let's get them resolved, and let's minimize the list, right? I think that's the ultimately, like, I know this whole concept of justice and peace is like, that's part of justice, right? Like, if the whole world is suffering from this pandemic, it's not that these people are benefiting from the pandemic, it's just a real situation. We need to move the more important cases forward, and the only way to do it is by being more efficient, right? I feel like you had another question there, but I might have missed over it. I'm not sure if
Well, I guess related to that, are you seeing better positions than offered from the Crown on resolutions, or is it similar to what you were getting before the pandemic?
and that's what I'm saying. Unfortunately, like, it's inconsistent between people. People are still people, right? So some crowns are being very reasonable. Some crowns are like, you know what? Like, we understand that being in lockdown and pandemic is almost like being in house arrest. So he is being punished on some level, right? So they might consider that. And in general, um, I I mentioned that prelim I did on Zoom last month, and I feel like we may get to a reasonable resolution because the Crown realizes, hey, to take this to Superior Court when there's, I think downtown Toronto Superior Court has about 12 or 13 homicide cases that are waiting to go, right? Like, these are like important murder cases that need to be heard. And for us to take this trial that is compared to those on a much lower scale, it's a waste of court resources that need to be used in other ways. So I think that Crown is being reasonable and considering having a decent resolution that will allow my client to rehabilitate properly into society, which is also one of the sentencing concerns that need to be addressed, sentencing principles that need to be addressed. So there are some Crowns that are definitely considering, but unfortunately, I don't think it's across the board. And hopefully there's more pressure from the higher ups to at least let the small things go, and let's get rid of the small things and focus on what's important. So that way, we don't see this kind of backlog in court.
Now, what about bail? Have you noticed? I don't know if you do much bail hearings, or have you noticed any difference in considerations? I know there's been some people basically like, well, because it's COVID, everyone's getting out. Is that true, or can you share about that?
So I have done a handful of bail hearings, and like I said, like, I think being virtual is helping me a lot because in the last month I had 2 different days where I had 2 bail hearings so I had 2 bail hearings in December on the same day, had 2 bail hearings in January on the same day. And that would have never been possible if I had to drive around and run back and forth between courts. Like, these are 2 different courthouses, able to get them both done, and all 4 of them are released, like, no problem, because of the virtual component and being able to email things and get things done on my computer while I'm in the office. Now, with respect to this whole notion that people are getting out for no reason, like, that's not the real way bail works. If you look at all the cases, or if anyone wants to go into the bail cases, they are saying, okay, this person is not releasable. They are more likely to breach, or their charges are serious enough where they have concerns about public safety, so they're being held in custody. Now, recently, if someone wants to Google Maplehurst, which is the institution where people are held in past Brampton in the West End, like near Milton area, that institution had about 90 cases. So when you have institutions like that with 90 cases, and it will spread quickly, right? So when you have institutions like that, it's very important to realize that the population in all these jails, they are vulnerable, right? Because they're in such close quarters. They don't have the best access to sanitary equipment or personal protective equipment. And that way things are spreading faster than it should, right? And all these guards are going home and coming back. So if a guard comes back with it, all the inmates can catch it quite quickly. Now, of course, the jails will tell you that they're taking all the precautions, this and that. I think one defense lawyer said, a Crown in his bail case said, technically the jails are safer than being out in public because they're forced to stay inside. And some of those things are ridiculous because it's like, end of the day, jails are crowded. You have a crowd of people, and that's the whole thing with the pandemic, is you want to avoid these crowds, right? So it doesn't make sense. Of course, they're more vulnerable because there are more of them in there. Now, some of the ways inmates are being affected is because of the jails trying to contain the pandemic, they're being forced into solitary confinement more often. They aren't having access to phones as often. I had a client who was in the Toronto South, and they were only allowed to have the phones for about an hour a day or something. And he was an elderly client, so the younger guys, they took over the phones for the hour. Now he's unable to contact me, and I need to hear from him to take instructions to tell the court what's going on, so I can conduct his bail hearing, right? Because I need to find out, does he have sureties? Who can I contact to have this bail hearing? So I had to like drive myself down to the institution, meet him. I had to talk to the guards there and be like, hey, like I need to talk to him. You have to make sure that he can access the phone. And after that discussion with the guards there is where he finally got access to the phone and was able to coordinate enough to have a bail hearing for him. Now, with respect to good things that I think the government's been pushing, the government started this one ankle monitoring program that is government funded. One of the reasons a lot of people can't go on ankle monitoring is you would have to pay out of pocket, and ankle monitoring is about $450 a month out of pocket, which a lot of clients can't afford. So the government, with some institutions, was able to set up this ankle monitoring. So I had 2 clients that signed up for ankle monitoring and they got released. This was both in Toronto, and at least this way, the concerns about, hey, can this person cause trouble while in public is a little bit alleviated because they're on ankle monitoring and they can be tracked at all times. They have to report to the ankle monitoring service at all times. And some judges have come forward and saying the ankle monitoring addresses a number of concerns for us. And even if like the fact that when the ankle monitoring is producing data at all times where this person is, and knowing that it's on you can have a psychological deterrence for somebody trying to commit another crime, right? So that's been a big step up from the government for having that service available for a lot of people. I think I've had 2 people released on ankle monitoring privately, and I've had 2 people released on ankle monitoring through the government and during COVID. So I think that's an important step. I do note that there are crowns that are doing good work and before even having a contested bail hearing, just saying, hey, like, if you can get me this and that, like, I'm willing to release this person. It's just, I need to make sure that they're not going to cause more trouble, right? So I think people are taking a better approach to it because of the pandemic, but I don't think the notion that, hey, anyone can get bail because it's the pandemic is true, because people are still going into custody every single day.
Now, you mentioned the things that the government are doing, and one of the things that I've noticed is certainly more digitization of disclosure and documents in the process through case lines and
Mhm.
from the Honorable Doug Downey's office there. Do you have any feedback, or you can share kind of how that's been in terms of accessing materials from the courts, as opposed to, I mean, before they would print everything and then you'd get the CDs. Like, first of all, you'd have
Yeah.
to find one of your computers that still had the CD-ROM player and remember the birthday of your client and all of that. But maybe you can share kind of how your experience with the disclosure has been.
Well, so unfortunately, it's not been consistent with every court. What I think would make sense to me, and what the downtown courts have been doing for me as well, is you know what, if you have a CD or DVD-ROM, like, you know, you can courier to our office and we can review it, so that way we don't have to go into court to pick it up. Now, unfortunately, I know there's some courthouses. I don't care. I'll name them. The Scarborough Courthouse and the Newmarket Courthouse. Like they for some reason are saying, hey, the client would have to pay for them to courier disclosure to us. And I'm saying it's the Crown's duty to get us disclosure, right? So the Crown's the one that should take on the expenses to send disclosure to us. Now, what Newmarket has done recently that's stepping up is they've started this program called evidence.com. So Newmarket and Oshawa are both on this website called evidence.com, where they can upload videos and large files, and we can download them off that. Now, all the courthouses are on this thing called Disclosure Hub, which is pretty convenient. It'll have all your clients there, and they even have a feature where if there's something that you haven't downloaded off Disclosure Hub, there'll be like a little red mark saying, hey, you should download this, it's new. Like there's something here that you haven't seen. So I like having that capability. Now, the one thing is, of course, now disclosure is coming in right away, and I don't think defense lawyers really have the excuse where we used to be like, hey, like the disclosure was prepared yesterday. I'm coming to court today, so I haven't had a chance to review it yet. Now it's like, okay, disclosure received yesterday is coming through the email, right? So it's sort of like changing the onus on us to get things done a bit quicker because everything's being received faster. So I think that's a good thing. Now, with respect to, I know some of my colleagues have concerns about disclosure coming online and whether there can be breaches of privacy of disclosure and all of that. And there's also some issues that some of my colleagues have with, there's stuff that we're undertaking to do with disclosure. So to sign into this disclosure hub, we have to like sign on to this undertaking automatically all the time. And some people, some colleagues, they don't want to sign a standard undertaking to do things all the time, right? Because like, are we going to be held liable for not getting, for example, one thing I think an undertaking I read had was within 60 days of the end of the case to return the disclosure back to the Crown's office. Now, the issue here is, let's say you do a case and your client's going to appeal or say that you were ineffective in some way or something, and you don't have access to the disclosure anymore. It could be an issue, right? So there's some issues like that where some lawyers don't want to sign these standard undertakings to receive disclosure. And we can't because it's all online, it's not like you can edit and manually like, hey, like, I'm going to cross this out and sign on this undertaking. So there's some issues like that, but generally speaking, I think it's a good way to move things forward. I think generally speaking, as long as the client's privacy can be protected through these sites, we're going to move things way faster. I think any law firm, once they can get the technology part down, like what I do is like, if I see the emails come in for disclosure, I'll try to download them on that day and have it exactly on that day to come in. And I'll know I have X amount of days to get things done and reviewed. I can send the emails out to them directly. All the crowns and courthouses have a virtual email now where somebody will be checking that email at all times. So it's not like, you have to go to your fax machine and send a fax out anymore. It's nothing like that. Like, everything's being modernized, which I like, because for me, like, once again, like I'm lucky because I'm younger. I can understand technology easy and it's working good for me. I don't know if some of the older lawyers who've been doing it the same way for 30, 40 years would share that same experience, because they've been doing it the same way for so long, right? So I think for them, it's probably a much harder adjustment. And these are some of the best lawyers in the city that have to change their whole life because of all these new practices. So I sympathize with them, but in the long run, I think it's definitely going to be beneficial.
Now, so just one of the questions that I certainly I get, and a lot of criminal defense lawyers get, especially if you're a defense counsel on a particularly heinous allegation, is, so how do you sleep at night, Sujith, knowing that you're advocating for someone who has been charged with sex assault or robbery or attempt murder or murder, and if you do your job effectively, you may be getting them off on these charges. And in particular, it comes up when there are charter violations or, in particular, and then charter violations, right? Because maybe there was a delay or the police didn't follow some procedure, and you point that out, and now this person's out on the street. What would you say in response to the people who say, who don't look at you as criminal defense lawyers? They don't look at you very favorably because of that.
Like, I get this question all the time, actually. Like from within the professional community, within the personal community, I think that question runs rampant. I've actually, I remember meeting people in public, and I would tell them I'm a criminal defense lawyer, and it's an instant turnoff for them, because they're like, "What? How could you do that job? If that's like, how can you defend these people, right?" I think for me, it comes back to the original, my inspiration for getting into criminal defense, which was, hey, like, these people, like, their lives changed. Like, they weren't the same people after that one run-in with the criminal justice system. So I think you truly have to believe that, one, if they did do it, or if they were guilty of it, there is a chance to rehabilitate them. I think that's important, that we can somehow fashion something to help them through that process. Two is, I think, within our system, that whole concept that you're innocent until you're proven guilty, I think that is very, very important, right? I think the fact that somebody might be guilty isn't enough, right? They have to be guilty beyond a reasonable doubt. And I think that's one of the reasons I enjoy criminal law, because the standard is high. And I think that's how tough the standard should be. There's been times where I've had someone that may have been guilty walk free. And there's been times where I felt that this guy, there's no way he could have done it. In my mind, he wasn't guilty of the crime, and he's getting convicted. And that felt a lot worse than seeing someone that may have done it get released. So for me, the fact that if someone is innocent and if they're going to get convicted, I think that's a huge concern. I think that combined with the chance to rehabilitate people, those are like two of the things that force me to be inspired to do this job every day. I think it's important to realize that in the last year, we've seen what letting police get away with small things ends up with, right? Like, I think obviously the most of the coverage was from the States. I'm saying it's likely that things like that are happening here, have happened here, of course, in the past, but are happening here to this day. And it's important that police aren't getting away with small things, because in their mind they're saying, oh, it's justice, it's justice, it's justice. But then it ends up gradually getting worse and worse, right? Like, if you're letting police get away with violating someone's rights, for example, the last case that I won was with respect to speaking to a lawyer, and my client didn't understand any English, and this police officer who's trained for like 18 years knows that if someone doesn't understand English, you should be facilitating some sort of language access to them so they understand their lawyer rights before they speak to a lawyer, or at least speak to a lawyer in that language of their choice. Now, this police officer has been doing for 18 years, and not only has he been doing it for 18 years, he also trains, he's a senior officer that trains other officers on how to be a police officer. And he failed to do that at all. And the judge in that case actually said it's the fact that this judge was so tone deaf to this situation, right? Like, it's an area of law that's been around for so long, and this police officer for 18 years didn't realize that this is what he was supposed to get done, right? So I think if we really want to see a systemic change with the way policing works and the way the system works, we have to not let police officers and Crown prosecutors get away with quote unquote small infringements of the charter, right? So I think, for me, I understand the argument, oh, like, this person's going to get off with some bullshit argument, right? But if you look at it, I don't think it's a bullshit argument. I think those kind of small arguments are what build the defense against the state, and the state using their powers inappropriately, right? So the fact, if a police officer is getting away for 18 years doing things the wrong way, who knows if one day he's going to lie and end up, and we see a tragedy like we saw in the States, right? So I think it's all about the small wins, and hopefully people can acknowledge and realize that, you know what, this is why criminal defense lawyers fight every day. And I think the most important thing that I once heard was, when a client comes into your door as a criminal defense lawyer and they're talking to you, there's nobody else in the world that's willing to bat for them other than you, right? So you have to be the only voice for them. And even though you might get the negative criticisms from everyone else, you're the one that they're trusting with their story and their voice, and you have to fight for them, right? It's not like you can be like, you can take your personal assumptions into granted. So for me, even if the allegations are heinous, I'm going to fight for him, and I'm going to bring his story out, and it's up to the court, not me, to decide on whether this individual is guilty or not. So if it's a heinous crime, for example, I mentioned in our pre-talk that I have a sexual assault coming up in March. It is quite, the allegations are quite heinous. And if the court deems that, you know what, these complainants are believable, this person's guilty, he will face a punishment, right? It's not that he's going to walk away, but that's not my job. That's up to the court to determine whether these people are believable. I have to listen to my client. My client's saying he didn't do it. I'm going to listen to him and cross-examine to the best of my ability and make sure that the court sees both sides, right? So, because I'm the only one that's there to fight for him.
Now, is there an area, like something that you would not touch for or within criminal defense?
So I think when I first started, I was thinking of some areas I wouldn't touch. I know particularly any sexual crimes involving children. I think that is my one area where it's, especially we're talking like child porn or molestation, like anything of that nature. I think that's one area where I personally have a lot of struggles with trying to defend it, because I think to be a good lawyer, you may have to look at the disclosure and see, like, hey, like, is what the police saying being substantiated or true? Now, there are ways, and if this is for any young lawyer or paralegal, if you don't want to ever work on a file for personal reasons, of course, like, you know, like, don't be afraid to like talk to your boss about it, right? If you're working for a boss and the boss is telling you to like look through a sexual assault file, for example, and perhaps you've been a survivor of sexual assault in the past, and that's something that's very triggering for you and you don't want to work on it, don't feel ashamed to have it, to go to your boss and like, hey, like, you know what, like, I personally just can't work on this file. That's fine. And for me, I just don't know if I could look at a child porn. Like, I think to visually like look at it, I think that would be a little scarring for me. So that's one area that I initially thought I wasn't going to get into. And I think as I grow my practice and develop more, I think I'm starting to realize the importance of understanding even someone that's going through a charge like that, right? I think there's always going to be some sort of mental health concerns there. Not always, but I think generally there's a lot of mental health concerns there and this and that. And those people who are being charged with child porn and those things of that nature, they also need help as well. And I think I'm starting to realize that, you know what, I can't let my personal views get in the way of things, because at the end of the day, of course, I personally don't agree with any sort of crime. I think all crimes are crimes, right? That's me across the board. There's no justification of drinking and driving. There's no justification of robbery. There's no justification of child porn. So for me, all of them are illegal. All of them should be crimes. And if I can do drinking and driving cases, then, and I'm defending this one person, I think I should be able to at least say, hey, I know you've been charged with child porn. I know it's a heinous crime and serious crime. Tell me your story and let me see if I can get you help and make sure that you come out of the system without having the book thrown against you. So I think as my years, now that I'm 3 years in, I think I've developed sort of that approach, and I'm hoping I don't get jaded to the point where I feel like, hey, I can't take on any case, right? So I'm hoping I can continue taking on cases as long as I can keep that fundamental approach where I'm like, you know what, this person's innocent until proven guilty. My job is to make sure that they're presented in the best light, give them the best defense possible, and it's not my job to make a determination on their guilt. That's up to the court.
All right, so I just wanted to pause. I think we're almost out of time here, but see if there's any more questions from any students. Just checking the chat. I think we've gone through everything in the chats there. But if anyone has a question, either just pop it in right now, or if you want to ask Sujith yourself, feel free to put your hand up or unmute and ask it on camera as well.
I realized I wasn't reading the chat, but I see some comments, I guess, were happening during our conversation.
Yes, I see a nice quote here. The true test for a society is how it treats its most deplorable members.
Yeah.
Now, Sujith, maybe if you have any final words of advice for my paralegal students who may be interested in working on summary conviction matters, maybe on their own, or if they want to work in a criminal defense firm, providing support to a criminal defense lawyer, any advice to kind of make the transition from being students and into the professional sphere? And certainly as well, if you were to talk to the students there in, I think it was Mr. Glass's high school class there in Middlefield, what would you tell them if they're interested in criminal defense law?
Well, I think for the students, I think that's easier because I can relate to them. I can tell them that it's not like every other area of law. I think if you look up firms, you can see like a civil litigation firm can likely take on litigation in any other different field. Like they can probably do personal injury if they want. They can probably do different areas because the concepts are similar enough. Criminal law, it's sort of a standalone. Most criminal defense lawyers are only criminal defense lawyers. I think the only two areas that sort of transition is you have some people that do criminal and family, because for them, when you have domestic clients, they usually have a family component to it. And there's a lot of criminal lawyers that also do immigration because, of course, both of those tie hand in hand. So I think to be a criminal defense lawyer, I think it really relates to what we just talked about earlier. I think you have to really believe and truly believe that approach that, hey, what I'm doing here is for this one fundamental reason. It's not, you can make more money doing other areas of law. The criminal defense is not about making money. It's not about, being cool. Like, it's not like you see on TV all the time. It's just about, hey, I believe that this is how we change the system. I believe that these clients deserve a defense. I believe that I can do my best and set my best foot forward, right? So I think that's very, very important. And I agree with Bryce's comment there, like the fact that the way you treat people, right? I know I can give you a little anecdote. I remember I was walking in Brampton Court and I saw this older lawyer, and he brushed a client, and a client, not my client, but somebody that was in the courthouse. And that guy turned around to the lawyer and he's like, "What the fuck, man? Like, you're not going to apologize?" And that lawyer sort of smirked and kept walking, and he didn't. For me, I was like, wait, like, he's still a human, right? Why are you treating him like that? He's still a person. Like, I know he may have done something bad or whatever, but treat him with more respect, right? I think you have to be able to have that kind of approach to really go into criminal defense and enjoy it. Now, with respect to paralegal, I think what I would suggest is there are some firms that do only crim and they hire paralegals full time, and those paralegals are awesome. Like, they're like on the point. They know the ins and outs of the courthouses. They're well respected. They treat everyone with respect. So I think they get things done efficiently, and I think they're assets to their firms. Like, if you look up some of the biggest firms, like I think Hicks Morley and Hicks Adams and some of the other ones, they have these paralegals that will knock it out of the park. Now, one of the things that I've noticed that I think is important for paralegals to know as well is some paralegals come out of college and they get their diploma and they start their own practice. And of course, one of the driving things are, hey, like, let me get money because, you know what, I need to get bills paid. And they take on some matters that are out of their realm of understanding, in the sense of the law society's imposing, right? The law society imposes the summary convictions and I believe as hybrid convictions that might be under 6 months, if I'm correct.
Yeah, it just changed to the 2 years, right? Because of the changes to the legislation last year. But pretty much the old summary matters and hybrid matters where they elect summarily, with some exceptions.
Okay, so, and you can correct me if I'm wrong, John, but so are paralegals allowed to do bails if it's still not, if there hasn't been any election done?
No, and my understanding is bails are treated as in indictable matters because they haven't made the election until after the bail hearing, right?
Yeah. So because I actually had an incident, not this weekend, but last weekend, where I had a client that was a former client. He had a matter and he was arrested. So the Crown had emailed me, and the Crown had said, hey, like, your client's here, he's up for bail, and giving me all the details. And then I called the family, and the family's like, hey, like, we hired someone else to work on it. And the person that was working on it was a paralegal. And then I emailed the Crown and I'm like, I don't know what to do here because, what, the family's saying that the paralegal is doing the bail. And so I emailed the Crown, and then basically the Crown and the duty counsel had to tell the paralegal that, hey, like, you can get in a lot of trouble for doing this right now. Like, you shouldn't be doing a bail hearing. And the paralegal was saying, hey, like, I was only going to assist duty counsel with the bail. Like, I wasn't doing the bail myself. But I think those are the kind of areas where, like, you can find yourself in trouble and burning your reputation with the Crowns and other people that you're in the courthouse and seeing all the time, right? Because now, because of that paralegal's actions, like, the Crown is very upset with me because the Crown's like, hey, was this paralegal working for him? Like, I mean, no, like, that was not someone that was working with me. That was someone that the family had found on their own. I'm not sure why he had decided to take on the file if he wasn't going to do the bail in the first place, because he should have just let me refer to him or like talk to another lawyer. Because what happened after was the client spent an extra day in custody because of that paralegal being involved in it one day, and the Crown was very upset. The Crown was like, we have a problem with all these in custody people. He could have been released from the station, but instead he went all the way to Toronto South because of this paralegal's involvement and it delaying the bail hearing a whole day. So for me, that was like a moment where I'm like, you know what, like, I think it's very important that you don't, even for myself, I don't want to take on things that I can't control. So that's why I never take on a real estate file. That I'll never, even if something I don't remotely understand, whether it's wills or anything, like, I'll always pass it off. So similarly, just being smart and just making sure that you build your reputation with the Crowns, and if you're getting to crim, especially the Crowns and other court staff, always be kind to them, and then eventually make sure that if you're taking on files that you vet them properly and don't take on files that could possibly either burn your reputation or, even worse, get you in trouble with the law society, right? I think that's my only advice that I can give to paralegals, because that was like a story that I saw recently where I was like, wow, like this paralegal's like, he's unfortunately, like, that Crown's never going to look at him the same, because the Crown basically ripped him apart in an email saying, hey, like, you shouldn't be doing this, right? So I felt bad for him, but I think he should have known the rules better, right?
Perfect. So thanks, Sujith. Actually, before we end, I know certainly on your Instagram there, you share about different hot spots in Scarborough to eat, being a Scarborough person. So maybe we can end here talking about where would you recommend for my students, since we can still go and, social distance, pick up food. Where would you recommend? Where in Scarborough should we be going to?
So I think one of the coolest things about pandemic is the fact that a lot of young lawyers are also starting their own firms. Similarly, like a lot of young businesses are finding the push to go out and start something because you know what, they realize either other employment opportunities aren't there, or they might as well bet on themselves, like Fred Van Vliet, and just get out there, right? So I think there's two new businesses that opened up that I really enjoyed. One is a wing place. It's at Morningside in Kingston called Just Wing It. And I thought they had really good wings. They do like this fries thing where they put shawarma on fries. It's really good. And then, so I'm Tamil, so I really like Tamil food. So there's this place just past Steeles, like near Markman 14th. I don't know if you guys are aware of the big Costco there. So in front of that plaza, there's this place called Appa's Original. Appa's is actually means dad in Tamil. They're actually on Blog TO today, and I discovered them about a month and a half ago, and they have good food. So those are the two new places that I'll be down to shout out. But of course, you have your classics all over the place that I'm sure you guys will find all over Google reviews. So you guys can deal with that as well.
Perfect. So thanks for that, and certainly you should follow Sujith there on Instagram, as well as on LinkedIn. Connect with him and ask him any further questions about criminal law. And certainly, thanks for sharing your advice there, and certainly best of luck with your practice and your upcoming trials. And he's popping the email there for anyone else that's here that wants to ask him questions by email.
Okay, yeah, I'll pop my email there. So thank you everyone for listening. And if you guys have any questions, feel free to reach out. My Instagram is also Sutharsan Law. Feel free to follow me or shout out me there as well.
Thank you.
Perfect. All the best. Take care, everyone. Thanks for joining.
Thank you so much. Good night.
Thanks so much, Sujith. Thanks, JP. Have a great day,
Thank you for
everyone.
the good work that you do. Cheers.
Thank you, Bryce. Thank you, Roxana. Thank you.